And today I will be your facilitator for this second session of our webinar series. And just before we start, I would like to maybe make sure that everybody can hear me, or if our technology is working. If you can hear me, can you please give us a thumbs up, or just put like on the chat box that yes, you can hear us, and then we can go ahead. Can everybody hear me? I don't see the thumbs up. Okay, so then we can go ahead. So on the 3rd of June, we had our first webinar where we spoke a lot about the role of the treaty here in South Africa, the Treaty on Business and Human Rights. And also we agreed that the voluntary guidelines that are used are not working, and that the existing international laws that are too weak, and also that they do not work on cross-border cooperation farms. We had Nhlakanipho explaining that, and also Ariela from Open Secret explaining that. So today, what we will be doing, we'll be moving from the why and how, and we will be exploring the articles that are on the treaty, Article 1 to Article 9, and also the session will directly prepare our civil society organizations and also the mining affected communities for the upcoming Indaba that will be held on 24 and 25 of June 2026. And also, before we actually look at the actual text of the treaty, we need to capture our current realities, or the live realities of the mining affected communities, as well as the people that work in these sectors. We have a Mentimeter that we prepared for the pre-webinar and also the post-webinar, just to see how we capture these realities before and also after the actual webinar. So I will share the links here now. As our speakers speak, we will then, after the webinar, share another on the post webinar, where we can also just like staple the differences, whether we understand or we don't understand. And the Mentimeter is entirely anonymous. So can you please just click? I will paste the link below here on the chat box. So also just to thank everybody, and that we will send over to our first speaker, Maxine, who will be speaking to us today about the Articles 1 and 2 of the treaty, and where she'll be outlining the purpose of this entire international text. Over to you, Maxine. Thank you.
Thank you, Ezile. I hope everybody can hear me and see me clearly. If you can't see me, I think hearing would be the next best thing. Thank you so much, Ezile, and thank you to everybody for joining this preparatory webinar ahead of the binding treaty regional Indaba that will take place in June, as Ezile mentioned. We are in June, later this month. Just a little bit about myself. My name is Maxine Bezuidenhout, and I lead the program called Alternatives to Extractivism and Climate Change at the Alternative Information and Development Center, AIDC, as it's known for short. And my work focuses largely on issues of corporate impunity, support to mining affected communities, critical minerals research, and a whole lot of other things which we don't have much time for today. But I will leave my contact details in the chat box if anybody would like to get in touch post this webinar. So with all of those things out of the way, I'll get straight into it. So this binding treaty negotiation process is more than 10 years in the making. I think what we all need to understand as important is that this is a state-led negotiation process. So the states, the countries that we come from, are the main negotiators in the room, and of course are the people that will need to vote on this as members of the UN structure and institution. But just because it is a state-led process doesn't mean that there isn't a role for civil society to play, especially communities who have been affected by extractivist activities. And so here I'm not just focusing on mining affected communities, but we're talking about agribusiness, commercial industrial fishing, logging, forestries, etc. So it's wider than just mining, and wider than just an attempt to regulate mining corporations, but extends to corporations involved in agribusiness, so the likes of Bayer, Monsanto, etc. You know the names. I don't need to go into that with you, but I think the main thing is that states engage in this process and negotiate in this process based on their own considerations and their own positions that they develop internally. But it also is, of course, influenced by the way in which the state engages with corporations and how it engages with other states, which all influence how it appears in the room, what the state delegation says, what informs those positions, etc. So they don't, state doesn't just walk into the room with its own agenda, but it's also playing a careful sort of diplomatic game, weighing up its national interests alongside diplomatic relations with other states, particularly where there are several, investment agreements in place, whether there are other bilateral agreements between states. This would influence how they engage on the treaty, what are the positions that they are taking, and who they are prioritizing in the way in which they are negotiating and entering into that space. So I think there's a lot we can say about this, and of course it lends itself to a particular direction in which communities can take when engaging their sort of respective states. I'm going to speak rather broadly and not too much on a particular South African approach to this as the binding treaty in Indaba as a regional focus. I'm rather going to speak generally and not specifically to the South African context. So I think, and as Izile mentioned, I will particularly zoom in on Articles 1 and 2 of the draft treaty text. but I think it's important to remember where we are in all of this, right? Because this conversation doesn't happen in a vacuum. While we are engaging on a webinar right here at this moment, TNCs, transnational corporations, multinational corporations, are continuing with business activities as we sit here. And it means that while we are sitting here, there are a number, if not thousands, of communities who are struggling against this architecture of corporate impunity that leaves communities to bear the burdens of environmental degradation, the erosion of socioeconomic rights, pollution, etc. And so I want us to remember that this is something that is, it's always happening. It's become our reality for the most part. And so even though we have this conversation now, the struggles on the ground continue. And so if we begin to look at Article 1, I particularly want to highlight that the way in which the treaty defines who a victim, is. And the current provision says that a victim is defined as any person or group of persons, irrespective of nationality or place of domicile, that's where you live, who individually or collectively suffered harm that constitutes human rights abuse in the context of business activity. And so this definition explicitly includes immediate family members and direct dependents of victims. This means that the draft definition for victim as it currently stands is broad and it is collective. It does not just single out communities or does not just single out individuals, but it defines the term victim to cover communities as well as individuals through this definition. I will say, as I go on, the definitions, comrades, are very important because the definitions determine who is included and who is excluded. So the fact that this definition of victim is as broad as it is as a result of the pressure that has been applied by civil society groups, affected communities, academics, those who are in the faith-based communities. Everyone has pushed and pushed and pushed to ensure that this definition is as broad as it possibly can be, because that is where that is who and where the justice needs to find its grounding. And so, what this definition of victim tells us is that, collective harm from dispossession, pollution, or the denial of consent is explicitly covered, right? But there are, as with most things, there are caveats, if you will, things that are, while there have been gains and victories made in some cases, in some senses of it, there are some, on the flip side, there are some things that are not altogether there, or as robust as we would want them to be, or as inclusive as we want them to be. but again, it is a negotiation process. We as civil society must continue to push for the broadest application of some of these definitions to ensure that it is as inclusive and as broad as possible um, through our collective actions and advocacy under the global campaign to dismantle corporate power and for people's sovereignty, of which many of you, I'm sure, are, and the movements and organizations you're part of are also members of this campaign. Has highlighted, however, that there is, there is some issue with Article 1, where the definition of victim is concerned. And yeah, and that there should be sort of perhaps explicit mention of particular vulnerable groups, but and that would be maybe indigenous peoples, rural and peasant communities, and the likes, so that there should be explicit mention of those groups, rather than just sort of broadly categorizing communities, which of course is still, everything is still up for debate, and this is, a live battleground as if you wish. And so this is something, it's an important point that we need to continue to keep pressure on, but also keep our eyes out and keep our finger on the pulse about, is that we cannot accept a narrow definition of what victim is defined as. And so what's important that communities can do in the meantime is to document collective harm. So this means if there is environmental contamination in your area, if there's displacement, if there's loss of livelihoods, if there is any evidence of human rights abuse in the context of business activities, it is our role as communities to begin to document that, because what often is needed in these legal cases is, of course, evidence, right? And so the stronger the evidence bundle you can put together, because otherwise it's he said, she said, and they said, and everybody said, but nobody's really saying. And so that collection of evidence is incredibly important at the domestic level. So that's within your national context, that this kind of evidence gathering is incredibly important to support advocacy efforts, but also to inform the kind of struggles that happen on the ground, and that these are, very much evidence-based in terms of what the community itself has been able to document, collect over a period of time, because a lot of what we are dealing with when we talk about human rights abuses and violations as a result of business activities is that these are not just once-off incidents that happen, but it is a longer-term sustained pattern of behavior that corporations have engaged in throughout, and there have been abuses and violations also throughout that process. And so it's important to, at every stage of the process, gather such evidence and it will show that, the definition of victim needs to be broad, because these are the kinds of issues that we are experiencing, and these are the reasons why we require such a remedy to be able to address these things, but also to prevent future harm, and to break this pattern of behavior that we are seeing of transnational corporations operating just as they will, coming in, bulldozing, polluting, and then they leave us with all of the damages after they've taken their profits elsewhere. And so this is, I cannot stress more the importance of documentation, gathering this kind of evidence through struggles and so forth. And there are ways in which these testimonies that communities put together can be taken to the negotiation room, and there's no reason why an affected community cannot take the mic and speak to a particular issue that they are facing in their areas and territories and localities. And what is important is that we if we've got an opening to speak to our governments in our different countries, to push for this explicit inclusion of a broad victim definition, so that everyone who is affected, who stands to be affected, who has been affected in the past, is able to have coverage by this particular provision in the treaty. So there are a number of other definitions which Article 1 outlines, and I will encourage that comrades engage with this definition article, because often, sometimes law can become a war of words, right? And what meaning is attributed to what word becomes incredibly important when we talk about a legally binding instrument, where there needs to be, we need to agree on what a particular word means. Otherwise, opening up to interpretation and inferences become a difficult challenge, and often, we don't want to get into a space where it is a war on semantics, a war on words, right? And you say victim means this, I say victim means that, or this state says this is what the word obligation means. This is another one says that they have a different definition of obligation, and so on it goes. So the definitions, comrades, are incredibly important, but in the interest of time, I'm just choosing to focus on the one in relation to victim. But I would suggest, comrades, please to go through the other definitions as listed in Article 1. The importance of Article 2, comrades, cannot be understated, because it is this legally binding instrument's statement of purpose, right? It's why it exists, and this is to be very explicit about the breadth of the provisions that this treaty is making, and and to infer to some of the context in which this instrument will need to operate in. So in Article 2 declares that the treaty aims to clarify and facilitate effective implementation of a state's obligation to respect, protect, and promote human rights in the context of business activities. It is to prevent and mitigate human rights abuses and ensure access to justice and effective, adequate, and timely remedy for victims, and strengthen mutual legal assistance and international cooperation. Now, I've said many words in that sentence, but obviously this is also in an attempt to simplify some of the treaty text, as it is quite legalistic and written in a way that's not as friendly as it needs to be for communities and for workers to wrap their minds around. And so it's important that we speak one another's language. Lawyers can speak their own language, the diplomats can speak their own language, but I think as communities and as workers, we need to be able to understand each other, and we need to be able to understand what the main provisions are of this legally binding instrument. And so what we see with Article 2 is that it is the treaty's kind of like model and legal, compass, because it puts the effective implementation on the obligation of states. So it is a state's obligation, a state's responsibility to respect, protect, promote human rights in the context of business activities. It's not the corporation's obligation to implement this kind of treaty. It is a state's obligation to do that, because we can't have communities bear the primary obligation to prevent corporate abuse. Communities already try to prevent corporate abuses by engaging in struggle, standing up for their rights, engaging with decision makers, submitting letters of demand or memorandums in order to have human rights abuses addressed. But this is on the prior end of things, right? So the before harm occurs is that this treaty puts the onus on the states to prevent that abuse from occurring. So I think that is something that we must remember, is that it is a prior process. So we're trying to prevent harm from happening, and it is the state's obligation to do that, because communities should not have to carry the burden of stopping corporations alone. What this treaty also aims to do is to not just ensure that the rights of communities are respected, protected, and promoted, but that in fact it gives states more of a legal muscle, to stand as intercessor between communities and corporations, and states need to play this role of oversight, of regulation, of putting things in place to ensure that its citizens, its people are not harmed by the activities of corporations and businesses in order to prevent corporate abuse. So, when a state allows a transnational corporation to proceed without free, prior, and informed consent, or without the correct environmental impact assessments, heritage impact assessments, biodiversity impact assessments, then the state would be in breach of its obligations under Article 2, because that would be completely against, what this treaty is setting itself up to do, and the powers it is conferring onto the state in order for the state to play the role of respecting, promoting, and ensuring that human rights in the context of business activities is of paramount importance, and that these provisions are not flouted. So if we're saying that communities have the right to consent, they have the right to say no, they have the right to say yes, and the state allows a corporation to continue without this consent of a community, then a community has grounds to approach the courts in relation to their rights given under Article 2. And so what we need to do here is we need to ensure that when, and particularly when we engage in struggle on these issues, that we can easily put the blame at the doorstep of a corporation, because their conduct and their operations are so glaring, and it's right in front of your face when a bulldozer comes wanting to break down somebody's house to make way for a mining pit, for example. But that there is a responsibility on the state, on the government, that they didn't protect you. They didn't protect the community from this harm. And so it's important to finger out, or to point out rather, where the state is also failing communities and workers, not just the way in which corporations are doing that. I mean, because we expect corporations to do this. This is what they, this is what they do. And so when we do our advocacy, and we do our marches and our pickets and our protests, it's important that we point out that the government has a responsibility to ensure that the way in which a corporation operates is not just a free-for-all. It's not just about maintaining the status quo, but it is about saying that the state cannot just wash its hands and say that this is not between us, this is between a community and a business. It's got nothing to do with us. They cannot wash their hands off of that. So while we finger out Anglo-American, we finger out Haiti and all of these other Bayer, all the financiers and investment companies that give these corporations money, is that we also look to our states, because they've allowed the situation that we experience to continue. So it's important that we continue to highlight that and amplify that in our in our struggles. And this also tells us, Article 2, that, free, prior, and informed consent is not optional. It is a must. Um, it is an ongoing process. It's not a one-time event. It's not just a tick box exercise, but communities have the right to give or withhold their consent, and that can be a final legal outcome. If the answer is no, that can be a final answer. Um, there doesn't have to be this, back and forth and trying to figure out, well, or trying to rather coerce or force a decision that says yes, but that when a community decides no, that no is no. And this is a process that must begin before any investment decision is made, um, so that communities have adequate time to conduct their own investigations, to have their own decision-making processes according to their own timelines, and all of those things.
Hi,
And
Maxine.
yes,
Sorry, so sorry. We have 2 minutes left for your presentation.
sure. I'll just wrap up.
Thank you.
So I just want to end off with saying that the demand for free, prior, and informed consent processes are deeply embedded into this binding treaty document, or the draft text rather. And these are particularly red line positions that we cannot falter on. These are the ones that we need to push, and to ensure that they are explicitly outlined in the binding treaty text, particularly FPIC, and particularly around who this treaty covers, and who it doesn't cover at this moment in time. So I in my previous point, where I was talking about the documentation of evidence, it's important to also document how the processes of FPIC are unfolding currently, to ensure that these are the kind of things that inform what the draft treaty text says on these things, and whether it covers particularly the kind of loopholes and accountability gaps we are experiencing currently. So I will end it there for now. But of course, when we have questions, please do engage, comrades. Thank you, Ezili.
Thank you so much, Maxine, for your extensive presentation. It's been very helpful. Comrades and everybody that just joined us now, welcome again. And we have put on the pre-webinar survey there. Can we please all fill in the survey before we move on to our next speaker, who is Philia? I will give everybody 2 minutes, and then we just fill in the survey, and then we go back to our next speaker. Just 2 minutes, everybody. Thank you. I will repost the link for everybody that just joined us now. Let me just repost it. Okay.
We're just waiting for everybody to click on the link before we go on to the next question.
Okay, Debatso is saying that it cannot open. Let me just paste it again. Sorry, comrades. Can you please let us know if it is opening now?
Good morning, everyone. Ezile, can I say something?
Hi, Brown. Yes, sure. Go ahead.
Yes. Uh, I agree with Ms. Bezenote with what she just said now. Most corporations, they more often rely on voluntary standards with oversight bodies responsible for monitoring compliance and issuing certification of compliance. This certification can enhance a company reputation and improve its rating amongst investors and independent organizations such as International Council on Mining and Metals, uh, ICMM, like ICMM, as well as its partners, the Church of Investors in Inland and various ISO-related organizations. However, our experience on the ground frequently felt differently. Uh, and then also, we have repeatedly observed like tailing dams that do not comply with the standards and they are certified against. And when the company affiliates it's with the particular standard bodies, it agrees to the terms and conditions of the standard, yet there is often significant gap between the reported and what is affecting the community actual experience. And then we also believe that it is important for this oversight organization to visit the communities and witness at first hand with the realities we faced, and they can accurately assess whether the conditions on the ground truly reflect to the commitments and the assurance made by the company they certify. And then also you will see these people and corporates, they will be joining on this voluntary standards, knowing that when we catch them and say this is not in compliant with what you are saying on the standard, they will use an opportunistic response to say, no, it's a voluntary standard, we volunteered. But if you volunteer on a standard, on a particular standard, even though it's a voluntary standard, if you agree to or you affiliate with those institution or bodies, you agree to their terms and conditions, and now you can't even find them where they are when we are facing things like this. And it's not only things like this, you get it also in air qualities, air quality management, they also does it. And then you will also find it on the EIAs when the people are conducting EIAs, especially the professions, they would refer they would they would refer the immediate communities they will not even refer the immediate communities. Let me put it like that way, because there is one that I've seen in our region, how they acquire even the mining license. They would say we are located in Marikana, in Vonorkop. They would refer Vonorkop to say the mining infrastructure is in Vonorkop, northeast of Rustenburg, 30 kilometers away. And then by doing that, you are undermining the immediate community that is almost 1 kilometer away, and then you would not even identify the real risk that these people are that we are facing in our community, because you go and identify someone in Rustenburg that is 35 kilometers away. So the immediate risk and hazard associated to the infrastructure can be identified, and then you can even really assess the risk, and that's how they are getting away with everything that we have been trying to do. And then also the government
Hi,
departments.
sorry. Hi, Brown.
Yes.
So sorry to cut you. Can we please reserve the last session for question and answers and also just for like our comments?
Okay, thank you.
Yes, thank you so much. Thank you so much for your comment. And thank you guys for filling in the Mentimeter. And to those that who have not filled it in, can you please, I have just posted the link again for the people that just joined us now, to please fill in the Mentimeter. And just to go back to the first session on what Mixin said, she said something really, really important and powerful, that these conversations don't just happen in a vacuum. As we speak now here, sitting in this webinar, or as we deliberate on everything and that we need this treaty to be about, there is a lot of human rights violations that is still happening. And going back to Brown's point, that as we're speaking now, so many dams are open, so many people are just go about without even being held accountable on the human rights violations that they do in their communities. And the second point is that the free and prior FPIC, to be precise, it's really important that the communities need to understand what they're agreeing to, and they need to, all these big companies need to go and do meaningful participations of the, or meaningful consultations with the companies, I mean with the communities that are affected by these whatever that the mining companies or the big national corporations are doing, or the business conducts that they're doing. So with that being said, we will move on to Philia Ngwaje, who will be speaking about Article 3, from Article 3 to Article 9 today. And after Philia's presentation, she will be we will be taking questions and answers. And I see that Maxine has just thanked our Comrade Brown for their inputs, which are really, really important, and would like to hear more from everybody who is from the mining affected communities, the civil society organizations that we work with, as well as everybody who is participating today. Thank you so much. Over to you, Philia.
Thank you, Ezile, and good morning, everybody. I really appreciate the platform. And I want to start off by saying that the value of an international legally binding instrument on business and human rights is that such an instrument is able to fill the gaps in international law, enhance legal certainty, and promote a level playing field for both states and business while promoting sustainable development and the rights of communities, right? As it stands currently, there is no legally binding instrument which holds multinational corporations accountable for human rights violations which they commit in various jurisdictions. So, for example, a company headquartered in America or wherever and operating in Ghana is presently very difficult to hold accountable for the human rights abuses that it commits by either the Ghanaian people or interested and affected parties. Therefore, in order for a legally binding treaty to be solid and useful, the instrument has to be, effective in one, protecting human rights, two, preventing abuses and violations, and three, it has to ensure effective access to remedy for victims of human rights abuses, as Maxine has rightly kind of put forward for us. So the legally binding instrument and treaty in its current form has a number of structural gaps and inconsistencies that must be addressed. And today I'll be taking you through some of them. But I will be focusing on those that mostly affect communities and those that have been seen as contentious throughout the treaty negotiations. So in the interest of time, I'll be going through Articles 3 through 9, but I won't be going through them in depth. I'll just be highlighting and flagging some of the contentious issues and about those articles. The first issue that I can flag for all of you is that some articles in the updated draft treaty defer to domestic laws, administrative systems, or suggest adjusting the provisions of the treaty to align with national frameworks, which weakens its role as an international instrument. And the reason this is problematic is that because rather than setting binding international standards that would apply universally to all states that are signatories to this legally binding instrument, the provisions would only leave it to individual states to establish standards through their own laws, which might end up being deficient and not meet the standards envisioned by the treaty text, right? That's why I'm flagging that. So effectively, let's get into the articles themselves. On Article 3, which relates to scope, which I believe is one of the most fundamental and contentious components of the negotiations, it speaks about the scope of the treaty text. And it's fought over because the treaty was supposed to apply to business activities of a transnational character. But the states are now debating whether or not it should also apply to all business activities. The updated draft treaty as it stands expands the scope of the treaty to all business, including micro, small, and medium scale enterprises. And this obviously departs from the objectives of the treaty. The objectives of the treaty was to address the growing power imbalance between states and corporations. Remember in the first webinar when Dlaganipo made the point that sometimes multinational corporations can have so much power that they sometimes tend to be more powerful than some small states? Well, that's exactly what the treaty was trying to guard against, the abuse of that power. And as a result, the treaty must seek to respond to those specific challenges created by the transnational or, the transnational character of multinational companies and not necessarily, focus on the companies that operate only on a domestic level. On Article 4, which relates to the rights of victims, and Article 5, which relates to the protection of victims, Maxine gave us a definition of the victims in accordance with the updated draft treaty text and how broad it is. And victims of human rights abuses in the context of business activities basically are said in the treaty text to enjoy all internationally recognized human rights and fundamental freedoms and be guaranteed the right to submit claims to courts and non-judicial grievance mechanisms of state parties to the legally binding instrument. So basically, the protection of rights holders and affected communities would be vital to ensure that victims and affected communities can secure access to redress and justice for the abuses and violations committed against them. But in conjunction, right, Article 5 is of crucial importance for the people and communities affected by human rights violations committed by transnational corporations, because in the updated treaty text, state parties are said to be responsible for the protection of victims, their representatives, families, and witnesses from any unlawful interference with their human rights and fundamental freedoms when they have instituted any proceedings that seek to access effective remedy, which then places the responsibility of protection on state parties. For me, this is important because often state apparatus colludes with business, which contributes to the human rights abuses that are experienced by communities, right? And the protection of rights holders and affected communities is vital to ensure that victims and affected communities can secure access to redress and justice for the abuses and violations committed against them. And this is in light of the intensification of attacks against victims and affected communities seeking accountability and justice. And now this brings us to a crossroads, because Article 5 fails to explicitly mention exactly what the obligation on state parties is to protect communities. Like, for example, to what extent do those responsibilities of state parties go? And that is the shortfall or the gap that I would seek to highlight in Article 5. So on Article 6, which speaks to the prevention, the updated treaty draft has not made sufficient progress in clearly defining the requirements for conducting due diligence. So although Article 6.4 includes due diligence obligations that companies must undertake, like human rights impact assessments prior to and throughout the company's operations, integrating a gender and age perspective, meaningful consultation, protecting the safety of human rights defenders or those that might be subject to retaliation, undertaking engagement in line with FPIC considerations, and taking particular account of the needs of those who may be at heightened risk of vulnerability or marginalization. And this would relate to, in particular, those groups like women and children or LGBTQI communities, community members. The current version of the treaty applies to all businesses, right? And flexibility must be allowed to small, medium enterprises, which may not have the same means as big multinationals. And this is just to say that when we're talking about conducting due diligence, small, medium enterprises might not have the same capabilities to conduct due diligence requirements to the same extent as big multinational corporations. And that's something that the treaty text must kind of take into account. And the treaty should not negatively then impact smaller businesses in that regard. But in the same breath, because it does not set out or define the requirements for conducting due diligence, it falls short in terms of prescribing exactly what would constitute due diligence and to what extent that would be sufficient, right? On Article 7, which is access to remedy, I'm going to couple this with a discussion around Article 9, which is jurisdiction, and you'll see why when I go into the discussion of access to remedy. One of the primary objectives of the proposed treaty is to improve access to remedy for affected communities. So while the updated draft treaty provides greater legal clarity on some procedural matters, it represents a step back from previous drafts with regards to contentious issues such as jurisdiction. The stumbling block happens because the article falls into the trap of state parties making domestic legal and administrative systems consistent with the treaty. And this, as I've discussed, does not allow the treaty to do the work of setting an international binding legal standard. It rather leaves it to states to create national laws by which then there might be differing kind of legal standards depending on the national laws of each state, right? And one of the ways is jurisdiction for access to remedies, right? Now, access to remedies must have something called extraterritorial jurisdiction, which means that it must not be bound by a singular jurisdiction, but that it must be able to be of assistance across borders. When we talk about access to courts and stuff like that, I must be able to have access to the courts, and that application of that access must be able to cross borders. So the reason why transnational corporations are operating with corporate impunity right now as it regards human rights abuses that they commit is that national laws that we currently have do not cater for extraterritorial application. Now, the updated draft treaty establishes the competence of jurisdictions where the human rights abuse occurred and where the harm was sustained. I'm going to simplify this. This means that courts are competent to can hear a case if the company committing the human rights abuses is headquartered there, number one, or if the state whose nationality the corporation belongs to can exercise jurisdictional power over that corporation, right? That's number two. Or number three, jurisdiction can be based on a victim's connection to the state where they bring the claim in a court. So we have three scenarios now whereby jurisdiction can be applied across borders based on these different frameworks, right? And then on Article 8, when we talk about legal liability, holding businesses accountable for human rights abuses that result from their operations was a key motivation behind the proposal for a legally binding instrument that can regulate corporate activities, making this one of the most contested provisions in like most of the drafts. The simplified version of Article 8 is that states must create laws that hold companies and individuals accountable for business-related human rights abuses, and including cross-border abuses, because obviously transnational companies operate across borders in a lot of instances, and they can be punished through criminal, civil, or administrative processes including when they help contribute to those abuses. And victims should have a fair chance to prove their case, and penalties should be serious enough to provide justice and prevent future harms. Now, once again, this idea of domestic legal systems applying to state parties comes into effect, whereby the provisions of Article 8 are significantly weakened a little bit, whereby when it says that states must create laws that hold companies and individuals accountable for business related abuses, if there isn't a set international standard, we're also expecting the same states, which often collude with business, to create the laws that would hold these companies accountable, whereby these companies, these transnational companies, have greater power in a lot of instances than the states. You know, there then becomes this interplay where there's a weakening of the provisions of Article 8, because there isn't a set standard for how the laws are going to be created and what is expected. And then secondly, one of the treaty's most critical elements is that the regulation of a parent company's liability. So it's essential to establish that that presumption of liability for a parent or controlling company throughout the entire supply chain. So, for example, if I am a transnational company and I have a bunch of subsidiaries, we'll call them my children, I should have liability for the actions of my children in whatever jurisdictions they are acting in. You know, we should be able to establish that kind of liability through the treaty. And the things that the updated treaty draft leaves to domestic law that could potentially hurt communities are the following. One, it does not clearly explain whether multiple companies or individuals can be held responsible together for the same harm. Two, it does not clearly state when a company can be held accountable for harm caused by another company or person that it controls, manages, supervises, or should have foreseen and prevented. And this goes back to the due diligence that we were talking about previously. Three, it does not include a rule that assumes that a company has control over entities in its corporate group or supply chain unless it can prove otherwise. So, civil society has been arguing for this, and really it goes to a really important point that I want to end on and close with, which is that the treaty remains silent on the connection between due diligence and legal liability for businesses. And what I'm saying by this is that there's a relationship between a company doing its due diligence and saying that because I've done my due diligence, I cannot then be held legally liable because I I fulfilled a certain requirement, and that is what I was supposed to do. So the treaty text does not incentivize businesses to implement due diligence requirements, which would to some extent limit liability. It really just says nothing and is silent about how the due diligence would have a relationship to the legal liability. And for me, at least, that is a little bit problematic and presents as a gap in how the treaty text is at present as a draft. And I think I will leave it there for now and hand back over to you, Ezile. Thank you.
Thank you so much, Comrade Philia, for that very important points that you have made. And also just answering the question that Maxine had for the community, like that, like here now, as we speak in these webinars, there is still human rights abuses that are happening. Then to answer on what should then happen now when these human rights abuses are still happening, and then we put into, like, we kind of like put on the meat on Article 5, Article 6. This is how we can use to make sure that these are preventative, and also how do we protect ourselves as communities. And also another thing that stood out for me, and maybe for everybody who is in this series, is that on Article 9 on jurisdiction, it would be so easier, and I know the communities would really appreciate having to be able to say, this company has violated our human rights, then we can go to the Northwest High Court and hold them liable for whatever that they've done, than being met with, oh, sorry, we do not have jurisdiction for this one. And with that being said, guys, can you please continue filling in the Mentimeter on your screens? And to the people that just joined us now, we have the Mentimeter. I have attached the link here. I will continue doing that. And then, yeah, we'll go ahead and open the floor for questions and the comments, if we have any. And also, guys, you can put on the questions in the session here on our meeting chat, and then we'll go through them. Thank you. And our first person, let me just go do this, is Mish on the mission. And then we'll be followed by Pumelele Matunjwa. Over to you, comrades.
Thanks, Fezile, and to the two presenters. Quite a very interesting information and vital for us to be able to engage and challenge these transnational companies. My concern, especially to the both presenters, Philia, and is that most of the time the companies or these transnational hide behind the national security principles or laws, for the for disclosure of information, so that we can be able to challenge them. So we need to look at the issue of the national security itself to be, transparent, so that we can be able, because they talk about classified information and all that stuff. So we need to be able to challenge that itself and make sure that we get the information that we want. Because most of the things that happen, I think, that we should look at is the issue of public, violations of, health-wise, environment, and all those things. And unfortunately, when sometimes we challenge that, there's this issue of national security ground that they hide behind it. So I would like them just to talk around that issue of how do we, unpack that, so that we can be able to hold these people accountable. Thank you.
Thank you so much, Bramish. We will get to your question now. Can you please go to you, Pumelele?
Thank you so much. Thank you to both the presenters this morning. Again, it was very informative. I think both my questions are from Comrade Philia's excuse me, presentation this morning. And I think the question almost flows also from the question I had from the previous sitting about the national laws versus establishing the international standards. So my first question is whether when this treaty, okay, the draft comes together and we have then that obligation on states to create laws, if I'm understanding correctly, that would hold TNCs accountable, would not doing that also constitute an offense attracting legal liability for not enacting those laws that are aligned with essentially the principles of this of this text? And then my second question was towards what you said towards the end of your presentation about the silence on the link between due diligence and legal liability. I wanted to ask whether would that constitute a separate offense from the liability flowing from the infringement of human rights violation? Thank you.
Thank you so much, comrades. I will hand over to Philia and Maxine, but we can start with you, Maxine, and then Philia will also get in and answer Pumelele's question. Thank you, guys.
Sure. Oh, the national security question. That's a tricky one and a stickling point. I mean, my perspective lends me towards the fact that well, at least in South Africa, we are a democratic country with particular institutions that need to serve a democratic mandate. Now, if we work on that premise, of course, this doesn't go into how the institutions have been co-opted, networks of patronage, corruption, etc., are embedded into these institutions. But if everything was working as it should be working, it means that Parliament would be required to play a stronger oversight role in relation to whether it is loans that South Africa is taking, whether it is bilateral investment agreements between South Africa and another state, or between South Africa and a corporation, and particularly have also play a stronger monitoring role. So if we are essentially leveraging the country's natural resources based on wanting to create mass employment, wanting to expand the provision of basic services to our communities, then one would have to monitor whether that trade-off and whether that relationship is delivering on the promises that were made as part of the agreement, and this also links to perhaps some of what Comrade Brown was talking about. Is hopefully, and I really am hopeful about this, is we get a really strong, enforceable, and robust treaty that is agreed to. But then the fight doesn't end there, right? That's only the fight that's taking place in the international or the global arena rather. But what we will then, the next leg of our fight will be a domestic implementation of such a treaty text and bringing that to life domestically, and Philia spoke to some of those issues. And once it's brought to life domestically, it again doesn't end there for us as communities. We need to take it further, and the fight will then become around monitoring and enforcement. So then we will have these really progressive laws and processes, regulations in place. But of course, how those things are monitored, whether there is compliance, and the capacity at which that compliance needs to be monitored, etc., is I think where a lot of our challenges will lie. But given all of these challenges, I'm not of the opinion that we shouldn't do anything. I think we still need to continue the way in which we've been organizing and mobilizing around this issue of the treaty. And I'm sure these are the same comrades that, should it come the time to monitoring and enforcement and all of those things, will be the same comrades that are pushing those, and hopefully others would have joined hands behind this. But the question of hiding behind national security imperatives, etc., has been used for far too long to cloud many of these agreements, investment agreements, bilateral agreements, into obscurity and very much sort of the word is opaque. It's you can't see, you don't know what's going on, and information is hard and difficult to come by. But I think there's a duty that we have to do in order to mobilize domestically around this treaty, because it's a shame that this treaty process has yet to be discussed at an active sitting of Parliament, and we must ask ourselves the questions why that is happening. And what we need to do domestically to ensure that this binding treaty is on Parliament's agenda. It's no use that it is just relinquished to the corners of DIRCO in Pretoria and the missions in Geneva, but that nationally and perhaps even in the National Council of Provinces, also as an important institutional body, that these issues get onto those agendas. It must begin to be discussed at our national level. Thank you.
Thank you so much, Comrade Maxine. Over to you, Comrade Philia.
Thank you so much, Ezile. So I think I just want to attend to the first question around. I'm not going to answer Comrade Mish's question because I think that's been sufficiently covered by Maxine. But Comrade Pumelele asked a question around national laws implementation and them attracting, legal liability for not being enacted. And I think, in relation to that, we just need to be mindful of the fact that states would have a reasonable amount of time to enact national laws after being signatories to the treaty once it comes into force, of course. And we also need to understand the process of ratification, because states would be able to agree to some articles and ratify those, and also not denounce certain articles. So they don't have to accept the treaty as a whole. And they can actually say that I agree with Articles 3, 4, and 5, but I don't agree with Article 9, and therefore I'm abstaining and it does not apply to me. So we need to understand those nuances when we talk about, enacting domestic laws and that attracting legal liability. And for the most part, those that are signatories to the whole text would need to enact legislation in accordance with the text within a reasonable time. But whether or not it would attract legal liability, that is not, it's not certain that it would attract legal liability, just because who would be the person instituting legal action against whom, which this is an international treaty, and it's not necessarily like, it's voluntary for states to sign on, and by making that commitment, they are saying that they are willing to abide by the conditions of the text. And so it's also taken that they will adhere to the requirements of the text. So where it says they need to enact domestic legislation, they would then, as responsible states, enact domestic legislation, right? So it's taken as a state responsibility, and with sovereignty and understanding that we should respect those boundaries, then the state would be responsible for doing that. So I just wanted to put that into certain perspective. And then there was a second question on the silence of the treaty text on due diligence, but I'm not sure I caught the question correctly. So if you don't mind unmuting Pumelele and just clarifying that second question for me, and then I can answer it.
No problem. And thank you for the answer to the first question. The second question was in relation to what you said about that there's a silence between the link between um the states having to do due diligence, sorry, no, the companies having to do due diligence, and then legal liability, whether not doing due diligence or what constitutes due diligence can attract legal liability. So then my question was whether not having done due diligence, whatever it might mean, would that not be a separate infringement to, let's say, the companies infringing upon human rights? Thank you. I hope that clarifies my question.
Yes, yes. So if a company has not done due diligence, because the treaty text does require companies to do due diligence at different points, and it stipulates the types of due diligence, human rights due diligence that need to be kind of complied with, or at least done, even though it does not set out specifically the framework for that. It says that, you would need to do, I just want to quickly refer. It kind of speaks about human rights impact assessments and, integrating gender and age perspectives, doing meaningful consultation. And there are certain kind of, for the human rights impact assessment, for example, you would need to do that prior and throughout the operations, for example. So with that, if a company does not do their due diligence requirements in that respect, that would attract legal liability. But in the case where a company does do their due diligence, but does not adhere to the prescripts of their due diligence, that is where the treaty text is silent on what happens in that instance. But if the company does not at all do a due diligence, because there's that requirement that would attract legal liability. I hope that clarifies it. Thank you.
Thank you.
Thank you so much to our speakers for clarifying all the questions that were heard. And I am not sure if Comrade Brown still has their question or their comment that they had initially, but also just to flag on what Philia spoke about now on the due diligence on how it should be a continuous exercise by the mining or any like transnational company that is operating within either the country or any affected community, and that if, for example, if the project is going to go on for about 10 years and then they do a due diligence in the first year and then they see that, okay, there won't be any harms, we cannot guarantee that in the process of doing all this, whatever operations that they're doing, there wouldn't be any new harms that are maybe discovered along the way. But the fact that these companies do not want to continue with their due diligence, they do it once, tick a box, and then they think that like it's a done deal. So a really important point on that. Thank you so much, comrades. And Comrade Brown has lifted up their hand, and after that maybe we can close, but these conversations are not ending here. We still have our big not mining Indaba, but the big business the binding treaty Indaba that is happening on the 24th and 25th, and we will be unpacking everything that we spoken about today here. You can go ahead, Comrade Brown, and then we'll close after your question and somebody has answered you. Thank you.
Okay. Thank you again for the opportunity, Ezile, and everyone to come and listen. I'm actually not gonna post any question. I'm just gonna give a background of where we just came from. Uh, we are located here in Markan, as I've spoken before, and then we have been like experiencing a lot of problems, and then we have been working with civil societies, also with lawyers for human rights, Benchmark, and other international partners. And then after we have seen that the company, the direct company that is mining within our area, uh, is not listening to us, or they always like giving a technical and opportunistic responses to us. So we escalated the matter internationally to the supplier to question the supply chain act. And then also the company also in international company, they've always responded to us with raw information from the direct company in South Africa without even verifying the things that we have been complaining about. And also you'd find everything on paper. It shows that everything is good, and then on the ground is inconsistent with what is on paper, because we have been submitting the evidence of the contradiction that they are saying. And then also we have taken up the case to the German government to at least to engage on the complaints that we have been complaining. But even now we are still waiting for the German government to come and give us the final verdict on our complaint. But our complaint has been substantiated from the process. It's as accepted, and then maybe furthermore we can like discuss these issues on the on the on the on the binding in Daba on the 24 and the 25. We can also like have a experience sharing on most of the things that are affecting. It's not all of this, but there is more or to the story as the directly affected. And then on that process, we had also to register our own non-profit organization so that we can also being address the issues as the directly affected communities also. Thank you for this opportunity. It really makes us a better opportunity to engage with other civil societies and other people outside the living conditions for us. Thank you.
Thank you so much, Comrade Brown, and thank you so much for sharing all the information. We, as lawyers for human rights, we know and we're aware of the human rights violations and also the work that the community organizations do on the ground and the matters that they bring to us. And we're looking forward to meeting everybody on 24 and 25 that have registered for our Indaba to have like a very important information sharing, like sessions. And lastly, to just put on the last Mentimeter that we had said we will put on the chat box, we have put the post-webinar survey. And can you guys please fill it in so that it will help us to determine whether these sessions are important and the gaps that we still need to fill in during the main Indaba on the 24th. And we can maybe stay in for like 4 or 5 minutes and then people should fill them in. And after that, thank you so much for joining us. We can all have a very wonderful Wednesday and stay blessed. Bye.